LONGLE. There is a $1,500 fine that will be probated. And I'm going to follow the TAP recommendation, and that's to be dual diagnosis, outpatient treatment with probation. And there's going to be 60 sober meetings in 60 days. And then Child Protective Services will be picking up your baby, and you will have a CPS case. And when you're released from Sympathy, that's what will happen. You will have to do parenting classes and everything else that's required of you. And when you have somebody, if you have your mom or whoever it is to come pick up your child at the prison, they will.
Today, we're in Judge Boyde's courtroom. And this case involves a mother who has shown time and time again that she is nowhere near ready to handle the responsibilities placed on her. She's been in front of the court so frequently, it's almost like she's collecting attendance points. And every chance she's been given to turn things around has been met with the same result. No action, no progress, and no real effort to change. It's as if accountability simply doesn't exist in her world. The judge has shown restraint, the system has shown patience, but even patience has an expiration date. And she's burning through the last of it at full speed, much like a defendant who suddenly realizes their plea deal is slipping away. As this hearing unfolds, it's clear we're reaching a turning point. We're about to see whether she finally decides to take control of her situation or whether she lets everything collapse completely. So the real question becomes, does she genuinely want to rebuild her life, or is she just going through the motions hoping everyone else won't notice? Let's go ahead and break down exactly what happens next.
For the state,
Jason Garahan, Your Honor.
for the defense,
Deborah Stanton, defendant.
and are you Miss Butler? All right, and according to your plea bargain agreement, there's a $1,500 fine. The state is recommending deferred adjudication. This is to run concurrent with 718-359 and 72869. The state is taking in consideration NIMAC number 752-652-760-865. All right, so if you were released from custody, who would you be staying with?
I'll be staying with my mother.
All right. And people will say that, but have you picked up the phone and called her and she wants you to stay with her?
Yes.
All right. Now she's under oath. Okay.
After her, I want to tell you something about me and her mom.
Okay. All right. Thanks. So do you have any children?
Yes, I have one son.
And what is his age?
His age is 2 years old.
And who does he live with?
He is not in my custody anymore. Yeah, I lost my rights.
Okay. And so what are your plans as far as employment? What are your hopes, your dreams, your goals?
My goals is to be a college graduate. I want to be a nurse, a RN.
Mm-hmm.
So when I get out, I do want to start school. I was already enrolling in the process, and then get a job.
All right. So what I can tell you is it's not impossible, but it's difficult. Anytime you have a criminal case, whether it's deferred or regular probation with a conviction, when you're seeking employment somewhere where it requires a license, it becomes more difficult, but it can be done because I know someone who actually went to prison, and I know this because I work with them to try to get their license and everything. Guess what? They're now an attorney. So it can be done, but you just made it a struggle. Okay. All right. Did you all want to speak to the length of deferred adjudication? It's in the plea paperwork outside the agreement. It's for 4 years.
Anything up to 4 years.
All right. So I'm going to set your deferred adjudication at 4 years deferred adjudication. If you complete everything successfully, you can always approach the court for early termination. But for early termination, I'm going to be looking at whether or not you've been positive, whether you've been reporting on a regular basis. You understand?
Yeah.
So there's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, and I'll say 30 days of release.
Yes.
There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. And the no unsupervised contact with minors, that can potentially change once you've shown me that you have everything, your life together. You understand? This will run concurrent with 718-359 and 728-369. Taking consideration NITMAC number 752-60865. Field visits one time per month for 6 months. 200 hours of community service restitution. If you complete a higher level education, or if you...
She's already starting off on the wrong foot, and the hearing hasn't even warmed up yet. It's great that she has goals and a plan, college, finishing her education, talking about becoming a registered nurse. That's way more ambition than a lot of other defendants ever walk in with. But Judge Boyd isn't wrong. It's pretty hard to become a nurse when your criminal history reads like the back of a mugshot trading card. Employers see certain convictions, and that's an instant application denied before you even get to the references. And losing her parental rights to her 2-year-old child doesn't exactly help her case either. The system sees that as a massive red flag. If she wants any chance at getting her kid back one day, finishing school, or even getting a decent job, she has to take these next 4 years of deferred adjudication seriously. Like life depends on it serious. Missing a single meeting over testing positive? Absolutely not. It sounds simple, just show up and stay clean, but when you're dealing with substance abuse, simple becomes a full-time battle. This truly is the state giving her a golden opportunity, the kind very few defendants ever receive. The judge is basically saying, look, I can't drag you to success, but I'm giving you the only shot you have left. And at this point, it's 100% on her to prove she deserves it, because the court has done everything it can.
She's barely stepped into the courtroom, and she's already heading in the wrong direction. And the hearing hasn't even begun in full. Yes, it's good that she has goals. College plans, finishing her education, talking about becoming a registered nurse. That level of ambition is more than many defendants ever show. But Judge Boyd isn't wrong in his reality check. Trying to enter a profession like nursing becomes nearly impossible when your criminal record reads like a highlight reel of bad decisions. Some convictions close doors instantly, long before an employer ever glances at your resume. On top of that, losing parental rights to her 2-year-old child sends a massive warning sign to the court. It's a painful mark on her record, and it raises serious doubts about stability and responsibility. If she ever wants to regain even a chance at getting her child back, completing school, or holding a solid job, she has to treat these next 4 years of deferred adjudication like the most important period of her life. There's no room for slip-ups. Missing a meeting? Not acceptable. Failing a test? Absolutely not. Staying clean and showing up sounds simple. But when substance use is part of the struggle, that simple becomes a constant, exhausting fight. And that's what makes this moment so critical, because the state is offering her something extremely rare, a genuine second chance. A chance most defendants never get. Judge Boyd is essentially telling her, I can't force you to succeed, but I'm giving you the last clear path forward. Now it's entirely up to her. The court has opened the door. The question is whether she's finally ready to walk through it, or whether this opportunity slips away, just like the ones before it.
And some sort of trade school certificate, the community service hours will be deemed satisfied. So it'll be up to you whether you want to end up picking trash up on the side of the road or bettering yourself with your education. You understand?
On the school, yes, ma'am.
There's to be no contact with Longley, Longle. There is a $1,500 fine that will be probated. And there is, I'm going to follow the TAP recommendation, and that's to be dual diagnosis, outpatient treatment with probation. And there's going to be 60 sober meetings in 60 days. And then we can go off the record. So in this court, communication is complete.
Yes, ma'am.
If there's an issue, let probation know. If you feel as though they're not a good case, always come back to the court. This is what I tell everybody. My goal is to be rehabilitated. If you feel as though you're going to take a drink, because you're not allowed to drink alcohol on probation or do any other type of drug, pick up the phone, call your probation officer, say, I'm struggling right now. Because that shows me that you learned what you need to do in order to be clean and sober. But if you're out here in this world and you're having problems and you don't let them know, guess what? We don't know and we can't help you. All right. Is there anything else you need from the court in order to be successful?
No, ma'am.
All right. And you want to tell me about her mom?
She and I are texting every day. She wants to know what happened now, today. So, yes, her mom's here.
All right. So they'll probably release you. It's probably going to be midnight. I have no control over
We
that.
have to make sure she's on bond in the 2 county court 7 cases.
So if you make bond for that, this court is not the court that will be holding you. It'll be the misdemeanor court. Okay.
Okay. Yes, ma'am.
24 CR 4982. State versus Briella Butler. Could I have parties announced for the record?
Jason Garahan for the state, Your Honor. Patrick Collins for the defense.
And are you Ms. Butler?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, and did you understand it?
Yes, ma'am.
Are you the same Briella Butler who's placed on deferred adjudication in 2024 CR 4982 for the offense of forgery of a financial instrument on February 12, 2025 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violate condition number 1 on or about the 22nd day of May 2025 in Bexar County, Texas. The defendant, Briella Butler, committed the offense of possession of a controlled substance, penalty group 1, in violation of condition number 1.
How do you plead to that? True or not true?
True.
I'm sorry, was that true?
True.
Thanks, ma'am. We'll waive the remaining violated condition, Your Honor. Yes, sir. Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
No, Your Honor, it's unagreed.
All right, state, what are you requesting?
The state is requesting adjudication of guilt and revoke for community supervision for 18 months in the state jail facility. One part of the agreement, we are taking into consideration the possession case she just pled to, which is JN 7143967. And we're also taking into considerations a county court at 2 case 2025 CC 0116.
It's heartbreaking to see that she already has 1 child and is now 7 months pregnant again. Yet she's still surrounding herself with people and situations that put her and her unborn baby at serious risk. You'd hope motherhood would push someone to rise above their circumstances, but instead she's exposing her child to danger before it even enters the world. And now, custody of this new baby will be removed immediately after birth. Not because the system is being unfair, but because her repeated choices have backed the court into a corner. At some point, the difficult question becomes impossible to avoid. Why continue bringing children into the world when the ones already here aren't being cared for? If she doesn't make a major change soon, her kids will grow up without knowing their mother beyond a case file and a few distant memories. Now she's headed into inpatient treatment, which, realistically, is her last real chance to turn things around. She avoided an 18-month jail sentence, but she'll still be spending 3 months in custody while waiting for an opening at the treatment facility. And she'll be giving birth while incarcerated, meaning no bonding time, no early nurturing, no first moments to connect with her newborn. That's a life-changing consequence. And it's hard to watch her stand there without fully grasping the weight of it. So here's the real question. Will this finally be the moment that forces her to change? Or will she end up back in Judge Boyd's courtroom, facing the same cycle all over again? Let me know what you think in the comments. Thanks for watching. Don't forget to like and subscribe, and I'll see you in the next one.